The Honourable Member Andrew Little.
Thank you, Mr Speaker. I rise to make this call on the Parole Extended Supervision Orders Amendment Bill and follow my colleague Phil Goff and just confirm that we are in the situation, the whole House is in the situation, where we are finding our criminal justice system now dealing with a very small number of offenders whose offending behaviour might be otherwise described as extraordinary, certainly unusual, and behaviour for which our criminal justice code has not found a way to deal with. And so, and particularly when it comes to sexual offending, sexual violation, and all its forms, there is one thing that must be paramount and that the House must give priority to, and that is the safety of our citizens, all citizens. And when the criminal justice system comes upon somebody who, having been convicted, having served their sentence, still, on any reasonable and objective assessment, constitutes a risk to the community, a serious risk, then it is absurd that there is, whether the prison system, the parole board, any other part of the criminal justice system is powerless to do anything about it. And it would be absurd if, knowing there were people who meet this description, who are of this sort of characteristic, should be allowed to be released back into the community, knowing that the chances of their reoffending and their chances of seriously harming, whether physically, emotionally or psychologically, somebody else is so great, then it seems silly that nothing could be done about it. And it's for that reason, Mr Speaker, that we support this legislation. We need to make sure, as we scrutinise it, as it goes through the Select Committee, that it does properly strike the right balance. And the Honourable Phil Goff talked about the expectations that we are all under when we consider legislation of the Bill of Rights Act and and the requirement, in a sense, to ensure freedom and liberty and all those sorts of things. But the problem we have, and the human institutions that we are responsible for here as part of the state, part of the machinery of government, is that we do come across people for whom the sort of conventional theories of correction and criminal justice simply do not apply. People who go through the system and whether because of their own psychopathic or sociopathic tendencies simply are not responsive to the measures that are exercised against them or to correct them. And they continue to pose a very serious risk. And so we have to be able to do something sensible about it, and this bill allows us to do that. As I said before, as the bill is scrutinised in the Select Committee process, then obviously a number of things will have to be considered, the thresholds that might apply. And I noticed that in the list of crimes that, or relevant offences as they are described in Clause 6 and the proposed amended Section 107B of the Act, of the Parole Act, it lists as one of the relevant offences a conspiracy to commit various offences. I'm not sure that a conspiracy to commit an offence which can apply on very narrow, or in fact a broad range and low level number of actions on the part of a person would constitute a relevant offence of given the type of behaviour that we're trying to address here. But that's a consideration for the Select Committee. I think I'm reassured later in the bill, particularly clauses 11 and 12, when it sets out the threshold that has to be met before an extended order can be, an extended supervision order can be imposed on an offender. And they are very high criteria that have to be satisfied. The offender has or has had a pervasive pattern of serious sexual or violent offending, and either there is a high risk that the offender will in future commit a relevant sexual offence or commit a relevant violent offence. But a pervasive pattern of serious sexual or violent offending, if that is evident, and also as a result of spending time in prison, a sensible assessment is made that this person simply is not rehabilitated, their behaviour still poses an extraordinary, or let's say high risk, then it is right that action is taken to protect the public. And I go back to the point I made, the priority must be for this House and its legislation on these sorts of matters. The paramount principle must be protecting innocent members of the public. And then in Clause 12 and the new Section 107 IAA in the bill, there's then a further set of criteria or matters that the court must be satisfied of when assessing the risk. So, Mr. Speaker, this bill is very thorough in the steps that a court must go through on receiving an application from the head of corrections before making an order of this nature. And it will be for the Select Committee and its detailed scrutiny to make sure that these provisions, amongst others, are properly weighed against the Bill of Rights entitlements that we all have, but against the background that the paramount objective must be protecting innocent members of the public and preventing the nasty, violent, insidious sort of offending that the bill is addressing. It is sad and it's tragic, of course, that we have citizens in our midst who meet the descriptions and the criteria set out in this legislation. And they have become known and they've been reported on in the newspapers and in the media. That is a tragic reality of modern life, that people have descended into those sort of dark areas and dark spaces in their lives. But we need to make sure that in the state management of those people, as they've been brought to book, that the state is not left in a position where, knowing there is a high risk of further harm and danger to people, the state is powerless to protect innocent citizens. And so on that note, Mr. Speaker, we will give our support to the bill and look forward to the detailed consideration as it goes through the Select Committee.
I call the Honourable Member David Clendon. Tēnā koe, Mr. Clendon.
Tēnā koe, Mr. Speaker.